In today's video, I'd like to talk about vlogging in public. So I thought what better place to introduce the video than in public? Well, sort of. I'm stationary, parked in a car park, just to preempt some of the comments there. And no, the car is not driving itself, even though it does it fairly well. The first thing we need to talk about is whether or not GDPR applies to you at all. Because GDPR, or the UK retained version, and the Data Protection Act are the primary bits of law that apply to the processing of personal data. That is, any information that can identify a living individual. Now, I say we need to determine whether they apply to you or not because this is widely misunderstood. For example, for domestic CCTV at your home, if it does not capture anything outside of the curtilage of your property, then GDPR and the Data Protection Act do not apply. However, literally crossing a line and a threshold, such as your neighbour's fence, may change that, because if your cameras capture audio or video outside of the bounds of your property, then the Data Protection Act will apply and GDPR will apply. That's not to say for your own house you need to register with the ICO as a data protection officer, but you do need to comply with the principles. And this has recently been upheld in a court case, which I will link in the description below, where I carried out a thorough explanation. Furthermore, if your activity is a wholly household activity, then it is exempt from GDPR entirely. The difficulty comes with vlogging in public and whether you are let's call you a citizen journalist, because you're out in public vlogging, even if that is just your personal vlog and you don't make any money out of it. Even more difficult if you do make money out of it, such as YouTube AdSense, but it applies whether you are just publishing videos for your own or someone else's interest. Then you will be considered a journalist of sorts. And the ICO, the Information Commissioner's Office, the UK's regulator for data protection, has published an update to its draft Data Protection and Journalism Code of Practice, which I'm going to go through in quite a bit more detail to explain how this works. And just as a heads up, I have a partner for this video called Incognito to help to protect your personal data. More about them a little bit later. But now let's get down to business, and you can see I've brought in the proper microphone for this bit. So let's take a closer look at the ICO's draft Data Protection and Journalism Code of Practice. This is a statutory code of practice which the ICO was required to produce under the Data Protection Act. It's been through 2 consultations so far, and there's been some amendments, and we are yet to see whether there are any further amendments to be made. The important reason I'm referring to this document is because it specifically refers to citizen journalists. Now, even before I dive into the document itself, citizen journalists could be me, you, your neighbor, anybody that grabs a camera, goes outside, starts filming, say, this looks good, this is entertaining, let's put it on YouTube. Let's see if we can get a YouTube channel going, maybe make some AdSense revenue, or just share it with your friends and family because it was interesting. Now, making something that's interesting, educational, informative, newsworthy, sharing an opinion, all of these kind of things can come within the journalistic exemption. But does that bring you as an individual within the remit of the Data Protection Act and GDPR? Most people would think not, but you may do. Because if you publish this, even if it's not for profit, European cases have suggested that, in fact, you may come within GDPR and data protection, albeit different states within Europe, albeit we've left Europe, but different states within Europe have interpreted this very slightly differently. But I get the sense from this draft document from the ICO that we're going to take quite a bit more broader approach to journalism. So whether you're watching me or Charlie Veach, famous mention there, I will tag him in the description below now that I've said his name, and you can go and say hi. Let's look at this document from the ICO. And we're particularly looking at page 12 of this one, which is, when are we using personal data for journalism? Now, just pausing for thought, when are we using personal data? Personal data is any information that can relate to and or identify any living individual. So if you can identify somebody from any of the information, or using that information in collation with any other information that you have, then it's going to be personal data and it may well engage data protection law. Ordinarily, as I stress, ordinarily applicable to organizations, but may apply to you as an individual in some situations, which is why we're talking about it here. I take the view that if you take the broad, cautious approach, which I will cover you within this video as guidance, not legal advice, you understand, but as a broad guidance to cover you as a citizen journalist within this video, I'm referring to this document here. So to rely on the journalism exemption, you must decide whether you are using personal data for journalism. In many cases, it will be obvious. In other words, if you go and film somebody in a public place for the purposes of journalism, newsworthy, entertainment, information, opinion, all of these kind of things, and you consider it to be journalism and you are filming someone and their face, by the way, is personal information for the purposes of the Data Protection Act because it identifies them. I think that's obvious enough. The number plate of a car equally is personal information that can identify somebody because you can identify them by other means through the DVLA and so on. They can be identified. Then you should interpret journalism broadly to include everything published in a newspaper, a magazine, a broadcast, radio, television, excluding paid-for advertising. So this would incorporate all of the traditional media outlets. So not citizen journalists yet. But it goes on to say, content published by non-professional journalists, including members of the public, for example, and spelling you, us out, citizen journalists such as bloggers, eyewitnesses, or social networkers. So this now is very broad. It includes me as a day-by-day professional producing videos for you and maybe out in the street for you to view, but also somebody creating a vlog, somebody as an eyewitness, they see something in the street and they decide to film it. They're an eyewitness. So you're filming for whatever purpose. You happen to catch something because you're an eyewitness and you film it. And therefore, maybe at one moment you're filming for your own purposes, your own home protection, safety, whatever it might be purposes, which would be the household exemption, not applicable with GDPR at all, because you're recording it for your own, like dash cams, you're recording it for your own personal safety. If you get into a collision, you've recorded a contemporaneous video of what happened. That would be a household exemption. You're using it for your own purposes. But you become an eyewitness if something happens. This is named and identified within this statutory code of practice, albeit labeled as draft, but we'll wait to see if there's any amendments. Draft because there might be amendments to it. Or social networkers. So anybody using social networks of any sort, captured broadly by this non-professional journalists category. Alternatively, material that is journalistic, but also being used for another purpose, such as campaigning. So you're out on a campaign for something or other. This would encompass that as well. If you're not sure whether you're using personal data for journalism, you should consider the specific circumstances, which could be the purpose of the publication, how closely it aligns with the media's traditional functions, such as holding the powerful to account, i.e. people in public office, the police, and so on and so forth. Whether you've made some attempt to align with typical journalist values, checking for accuracy. If I were to produce videos and criticizing somebody for something, I will check the law. I'm checking the accuracy. That's not to say I'm always going to be 100% accurate. That would be silly to say. If I find that I'm incorrect and I've got reasonable notice that I'm incorrect about something, you can be assured that I'll come back and say, actually, just to clarify, there is something else to say here. So that would be an example there. The content of the information, including any public interest in the publication, i.e., is the information within the content worthy of public interest? Would the public have interest in it? Is it a broad public interest? Is it a narrow public interest? And to the extent that you have or you will promote this information to the public. And just in case you are a vlogger of just entertainment and this doesn't seem to apply to you, the ICO Code of Practice goes on, and in my view of reading this, expands this very slightly further. The above factors are not exhaustive, and whether they are relevant and the extent that they are relevant varies case to case. For third-party content or online user-generated content, you could consider whether you've applied editorial judgment for the third-party content, deciding whether to include a reader's response. However, all of this comes with a caveat, which is when we are acting with a view to publication, to rely on the exemption, you must also intend or hope to publish the journalistic material. You publish material when you make it available to the public, even if it's not accessible to all members of the public. For example, there's a subscription or a paywall, so not necessarily open to everybody, maybe on a private forum or something like that. Where you intend or hope to publish the journalistic material, the journalism exemption can apply to all the personal data you collect or use as part of the activity. And it doesn't matter whether you actually publish the story you had in mind using the personal data. You can retain the personal data to use in a different story in the future, or update the story so you've already published. And now we come on to a very important principle of reasonable belief. But hold that thought. As I said earlier, I have a partner for this video, which is called Incognito. And I'm very proud to be partnered with Incognito because it will help to protect not just my data, but your personal data as well. Because I'm able to share exclusive discounts with you at the link in the description below. Because in today's modern digital age, our personal information is more vulnerable than ever because it is in several accounts and in various places all across the internet and stored on who knows how many servers and by whom. And not just storing your data, they are even selling your data. You can even fall victim to several types of fraud, because if somebody uses your details, your name, your address, if they have your date of birth and various other details, and they commit some kind of fraud in your name, then you, the real you, can end up on a fraud database, which can take a great deal of time to unravel to prove that it was not you involved in that fraud. But in the meantime, I personally know of, well, some clients of ours and some other people that I know personally who have had their accounts forcibly closed because they ended up on a fraud database. But even if you wanted to do this, how would you go about asking these companies to remove your information from their servers when you don't even know who they are? But with Incognito, they provide a simple, seamless process whereby you ask Incognito on your behalf to contact all of these data brokers that sell your data to all sorts of marketeers and other companies around the world. It provides them with a formal request on your behalf to ensure that all of your data is removed and prevented from being used in any kind of marketing services or third-party databases. I am going through this process myself, as you can see my updated report that I received just a few days ago. And it takes some time to go through this, but not time for you. Your process is very simple. You sign up at the link below, which you'll get an exclusive discount for. It walks you through a very simple process, and then Incognito will do the rest. You sit back and watch the report update as to when each of these companies confirm that they've complied with the formal request to remove your information from their servers. Like many of you, I have been concerned about my personal data being stored and shared and even sold without my consent. I am currently party to several claims, along with thousands of other people, against companies for leaking our personal data. You don't have to look very far to find these companies in the news being fined for their data leaks. For example, Lime Leads, Dealer Leads, Apollo, even Equifax, and even LexisNexis. Many of these companies have leaked thousands or millions of records of data, but you can help to avoid all of this by signing up for Incognito at the link in the description below. And I thank you for allowing me the time to thank my partner for this video. And now let's get back to talking about vlogging in the street. And so now, after that brief break, what does a reasonable belief mean? Well, to rely on this exemption, you must reasonably believe that this publication is in the public interest. So any sort of interest for the public. and complying with the specific part of the data protection law, i.e., not publishing it without their consent and things like that, would be incompatible with journalism. In other words, if you wanted to publish something which you couldn't if it was in contrast with GDPR and data protection law, but you need to, for journalistic purposes, those two being incompatible, you reasonably believe that if you were to comply with the data protection law would prevent you from the journalism, therefore it's incompatible. That is your honestly held reasonable belief. Now, the important bit, in my view, is as follows. You do not have to prove that the publication is in the public interest or that complying with the data protection law is incompatible. You don't have to prove those. In other words, your view could be different from a judge or even from the ICO. You don't even need to arrive at the same conclusion as the ICO. And this is the ICO saying this, or a judge for that matter. Different and opposing views may both be reasonable, but you need to demonstrate that the reasonableness of your decision in coming to that reasonable belief. But going back to what does in the public interest mean, this is also fairly broad as well. A lot of public interest elements will be quite obvious, i.e. if there's a serious news story that the traditional media outlets will be covering, that is typically going to be in the public interest. And to decide what's in the public interest, generally for those things, you can consider the independent press standards, the BBC guidelines, and Ofcom code, but also consider the circumstances, balance the factors against the publication, i.e. are there any factors that go against you publishing this material, and judge how the public interest is best served. When thinking about photographs or filming, especially in public, this code of practice also has a section for that, which is reasonably fair. You should keep in mind that photographs or film may be particularly intrusive, and the impact may be greater if you are continually photographed or recorded. I've mentioned this before. If you continuously follow someone around filming them and they don't like it and they don't want it, that would be different than just a brief interaction because they came up to you, started talking to you, or they are incidentally included. The two are very different. People should reasonably expect that there may be sometimes photographs or caught in film in an incidental way, as I just said. However, if the person's image is captured in public and they are the subject of a photograph or film, you must consider whether using the personal data is fair in the circumstances, even if the activity is in a public place. Now, I've mentioned this a number of times. So if you follow somebody into a shop and then around and then, at worst, into the bathroom, that's clearly wrong. It's very different than being incidentally caught in a public place. But also, and just to round that off, earlier in the document, it does talk about how the code takes into account the special public interest in the freedom of expression and information, and makes clear that there is a strong public interest in a free press because it's vital to democracy. It can increase knowledge, inform debate, entertain, which is very broad, and help citizens who participate in society, and all forms of journalism can perform this crucial role, including local stories, entertainment news, and major investigations. So all in all, if you are a citizen journalist, vlogger, blogger, or just taking random films outside, you need to bear in mind that some European cases may end up convincing a court, if it ever went that far, that the Data Protection Act applies to you, even though the ICO's view is that a body-worn camera does not bring you within the realms ordinarily of GDPR, because they see that as a household exemption. But if you are planning to film this material with a view to publishing it as journalism, then you might keep in mind this code of practice, which means whilst you'll probably be able to rely on the exemption for journalism, some of the elements will still apply. For example, keeping the information secure and only keeping it for as long as necessary, which is pretty vague, but still only as long as necessary. So if you don't publish it, but you store it insecurely and lose it, then you may still be in breach of the Act. So I'll link the code of practice in the description below. Go and read that if this will apply to you or you think it might apply to you. Seek formal advice on your specific circumstances if you're not sure whether this applies to you and to what degree you have to comply with it. And in the meantime, you should rest assured that as long as you're not doing something that is very broadly unacceptable and would be obvious to many, that the journalism exemption should not outweigh the rights of the individual and their privacy in their personal data, then in most situations, you're going to be just fine. But as always, this is an ever-changing landscape. I will always come back and update as these things change and evolve. But in the meantime, please do hit the like button and subscribe. Thank you for allowing me the time to mention my partner for this video. And as always, thank you for watching.